An excerpt from the Supreme Court decision in the case of Francis D. Malaki and Jacqueline May A. SALANATIN-MALAKI versus People of the Philippines. Francis and Jacqueline were charged with bigamy in an information which reads that on or about June 18, 2005, in the municipality of New Corella, province of Davao del Norte, Philippines, the above-named accused Francis being previously united in lawful marriage with Narian on March 26, 1988, and without the said marriage having been legally dissolved, did then and there willfully, unlawfully, and feloniously contracted a second marriage with Jacqueline. On arraignment, Francis and Jacqueline pleaded not guilty to the charge. Trial then ensued. Narian claimed that on March 26, 1988, she and Francis were married under the religious rites of Iglesia Ni Cristo in Panabo City, Davao del Norte. They begot 2 children. In 2005, Francis left the family home for Tagum City to find a job. He later abandoned their family. Narian discovered that he was cohabiting with Jacqueline and that they contracted marriage on June 18, 2005, solemnized by a municipal trial court judge. Francis and Jacqueline admitted that they got married while Francis' marriage to Narian was subsisting. However, they claimed that they could not be penalized for bigamy as they converted to Islam prior to their marriage. The regional trial court found Francis and Jacqueline guilty beyond reasonable doubt of bigamy. It reasoned that the Muslim Code and the Supreme Court in the case of Zamaranos versus People do not govern the circumstances of Narian, Francis, and Jacqueline, considering that Narian is not a Muslim. On appeal, the Court of Appeals affirmed the regional trial court. The issue for this court's resolution is whether or not petitioners Francis and Jacqueline are guilty of bigamy. Subsumed in this is determining whether or not a party to a civil marriage who converts to Islam and subsequently marries under the Muslim Code is exempted from criminal liability. The Supreme Court rule against Francis and Jacqueline stating that a party to a civil marriage who converts to Islam and contracts another marriage, despite the first marriage's subsistence, is guilty of bigamy. Likewise guilty is the spouse in the subsequent marriage. Conversion to Islam does not operate to exculpate them from criminal liability. Further, a married Muslim cannot marry another. In exceptional cases, a married Muslim man may do so if he can deal with them with equal companionship and just treatment as enjoined by Islamic law. The formal requisites of the subsequent marriage under Presidential Decree No. 1083 or the Code of Muslim Personal Laws of the Philippines or the Muslim Code entails the wife's knowledge of the impending subsequent marriage.